We see it all the time in TV and films. When it looks like this, we applaud it. Sometimes we even laugh. But when in real life, when it looks like this, we go to great and often tragic lengths to condemn it.
Night in a row, anger flooded streets across the deeply divided country.
Welcome back to Law Dogs. I'm Jeff Henley, your host, and with me as always is Annabelle. Today's topic, excessive force. Now, excessive force comes from the merging of two different bodies of law, tort law and constitutional law. Typically, when we're talking about excessive force, we're talking about the violations of one's Fourth Amendment rights. Now, when we're talking excessive force, we're talking about a category of law that borrows from two different areas, tort law and constitutional law. Now, with tort law, we've already talked about battery, a harmful or offensive contact. Now, besides battery, we're talking about Fourth Amendment constitutional violations. That is not state common law torts, but Fourth Amendment federal constitutional violations. As a result, in most instances, when you're talking about police brutality, you are traditionally and most frequently talking about Fourth Amendment violations. The claims are rooted in the Fourth Amendment, which states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. As you learned from your high school civics class, the founders included a Bill of Rights, which included a number of different protections against government authority. They learned these lessons from the British Crown, which had oppressed them in a variety of different circumstances. One of the biggest, the most central to those, of course, was the ones that are enshrined in the Fourth Amendment. Being free from unreasonable searches, and when it comes to excessive force, unreasonable seizures. So when we're talking about beatings, shootings, clubbings, smackings of any kind, we are talking about vindicating Fourth Amendment rights under the unreasonable seizure clause of the Fourth Amendment. But Law Dogs, did you hear or see anything in the Fourth Amendment that said you could sue over such a violation? Nope, you didn't. Nowhere in the Fourth Amendment does it say if your right is violated, you have a right to sue. That right comes from someplace else. Following the Civil War and the departure of Union troops in the South, the Ku Klux Klan and other groups committed widespread lynchings, murders, rapes, and arsons. Even worse, local governments were powerless to stop the terror or often facilitated it. Local governments were incapable, indifferent, or hostile to advancing the rights provided blacks under the newly passed 13th, 14th, and 15th Amendments of the U.S. Constitution. Because the South was allowing these abuses to occur, President Grant urged Congress to pass a series of acts that would give meaning and force necessary to carry out the rights that had been guaranteed under the 13th, 14th, and 15th Amendments. One of those acts was what is called the Civil Rights Act of 1871. Sometimes it's called the Ku Klux Klan Act or the Force Act. In that act were the provisions that would secure the enforcement of constitutional rights. The essence of the statute states that, quote, every person who acts under color of law who subjects or causes to be subjected to any violation of the Constitution or federal law shall be liable to the injured party. The statute thus gave parties the right to sue local officials who failed to protect their communities from the Klan and other terrorists. The statute is presently codified in Title 42, United States Code, Section 1983. As a result, you'll often hear lawyers refer to police brutality claims as Section 1983 claims, or even 1983 claims. Now, what's important to note about Section 1983 is it is not just applicable to excessive force claims. It is applicable to any kind of action that someone may file because his constitutional rights are being violated or because her rights under some congressional act are being violated. Section 1983 is a procedural means of enforcing some substantive right. Stated another way, the Fourth Amendment is the what is being violated, and Section 1983 is how you remedy its violations. Now, we've just scratched the surface of police brutality claims. In future episodes, we're going to talk about what is necessary to make one. If you have any questions about this episode or any others, you email us here at Law Dogs. We'll see you soon. Until then, you stay out of trouble or the Law Dogs will get you.